Hi, in this video I'd like to provide a quick comparison among the three primary intellectual property instruments that I handle in my office, which are utility patent, design patent, and trademark. In a previous video, I already discussed what these instruments are for, and at this point you should be pretty clear on which one would apply to you. So the next question becomes, what do you need to actually get one? This video will just be a pretty quick comparison and overview to show the similarities or differences among these three instruments. It's basically just a chart that I'll walk through with you. Following this video, I will make others that will dive in more deeply to each instrument. So here's the comparison chart. Again, we will be discussing utility patent versus design patent versus trademark in terms of what is required of you. And these are the 6 particular questions that we are laying out in this chart. Is it required that you created the work? Is the right created automatically? Do you need to be actually using it? What are some other requirements? What does an application cost? And what should you expect in the long term? Okay, so let's take this table from the top. Is it required that you created the work? The answer for both kinds of patent is yes, and for the trademark it's no. Occasionally I'll get someone who comes into my office, and they might be an importer or someone who works extensively with factories in China or some other kind of international trade, and they will have seen something in a different country, and they think, nobody seems to be doing this in the US. Maybe I can get a patent on it in the US so that I can be the first and only person to import it. Well, that's not possible. A patent can only be issued to the person who actually invented the product. So if you see something exciting in China, that means somebody has already invented it. And that person only would have the right to file a patent application for it in the US or any other country. You do not have the right to a patent on something just because you are the first person to, quote, introduce it to the country. Now, for a trademark, on the other hand, remember that trademark is not really about inventorship or creative works as much as it is about protecting consumers to make them aware of the source of goods. So you can go ahead and start a business where you might be rebranding and selling a line of clothing that somebody else designed. It doesn't, the clothing, the underlying product, does not have to be your invention. And furthermore, you might be interested in using a logo that you didn't create. Maybe you hired a graphic designer to make it. That's completely fine. Or you might want to describe your store with a phrase that has existed for 100 years. You didn't make up the phrase, but it just might be a good way to brand your store. And in all of those cases, that would be fine. So creativity is the hallmark of patents, but not of trademarks. Okay, the next question is this right going to be created automatically? The answer for patents is no, and for trademarks, just like copyrights, it's, well, yes and no. So patents are very clearly not created automatically. If you want a legal monopoly on your invention, which is one way of describing a patent, then you have to affirmatively take steps to file an application and go through the approval process. It's difficult and it's expensive. It does not happen without your effort. Trademark. Well, so when you start using a brand name or a logo to sell and brand your goods, it automatically creates a certain kind of trademark protection. It's called common law protection. Common law trademark. There is an analogy in copyrights as well. And what that essentially does is it would give you the right to exclude others from using your brand name or logo for similar goods in the same geographical area. And that would probably be limited to like a city if you're a local business. But what is not created automatically is the registration, the registered trademark. So that's usually what we think of when we talk about trademarks. You would have to actually affirmatively fill out an application form and submit it to the United States Patent and Trademark Office, and again go through the approval process before your trademark is registered. A registered trademark gives you protection over the entire United States without any question. And that can be a benefit whether there are other people who are selling goods similar to yours or other people who are looking for a brand name that's similar to yours. Because essentially it makes the trademark examiners well aware of your mark. The next question, do you need to be actually using your product or good in order to get this protection? The answer for patent is no, but for trademark it's yes. So you can actually get a patent on something that doesn't exist physically. It doesn't have to be in commerce. There doesn't even have to be a prototype. For a trademark, however, there is a requirement that you must be actually using your mark in commerce. You must demonstrate with what's called a specimen that you are currently using this brand name or logo to sell some particular good or service. What are some other requirements? For patents, the statutory requirements are given the names of subject matter, novelty, non-obviousness, believe it or not, enablement, and the first inventor to file. Those requirements all apply to both utility and design patents. And there's a lot packed in there. So I'm going to save that lengthy discussion for my future videos, which I'll record separately for utility patents, design patents, and trademarks. But just be aware that these are some of the requirements that will be asked of you. For a trademark, the requirements are that your trademark must be available now in order for you to register it, and the brand name must be a distinctive one. So again, that will be unpacked in my trademark video later on. The only thing that I really want to draw your attention to here is the comparison between novelty and availability. So in order to get a patent, your invention has to be novel. And that means that it's an invention that has never existed anywhere in the world before. So if you want to get a patent on your better mousetrap, you need to be able to explain something about this mousetrap that has never been seen, that has never been described publicly anywhere in the world. If somebody described it in a magazine in Senegal 150 years ago, then you're out of luck. It's been disclosed, it's not novel, and you can't get a patent on it. By contrast, a trademark only has to be available now. So when you look up trademarks, like brand names, for example, you'll see a list of a bunch of brand names, and you'll notice that some of them are marked as live and some of them are dead. So it's the ones that are live that you have to be concerned about. If there's a brand name that says dead, it essentially means that somebody used to have it registered or applied for it. It could have been 30 or 50 or 100 years ago. But if it's dead, they're no longer using it. And that means that you can claim it now and use it yourself. You can register it yourself. So it only has to be available now. It's okay if it's existed in the past. It just has to be unregistered now. The application costs. These are ballpark figures, and they're essentially for what you would expect to pay if you work with me. Most of my clients end up spending approximately $4,000 to $6,000 to file a utility patent application. Approximately half of that, $2,000 or $3,000, for a design patent application, and maybe about $1,000 to $2,000 for a trademark application. If you want to go to a large law firm, you can probably expect to pay twice as much. The main advantage that a large law firm could offer you that I can't is really just their litigation arm. I don't practice litigation. So if it's important to you to work with a lawyer who both prosecutes, who both procures applications and litigates them, I won't be able to provide that service to you. But just to kind of make you aware, that's primarily the reason that those firms are so expensive. The big money is in litigation. You can also cut these costs in half if you want to go to a firm that might be called like an inventor services firms. And as you might imagine, there are risks to skimping, which I'll discuss further when I make my other videos. But the main point is that the more you skimp on your upfront costs, the more trouble you might expect to get into later on down the line when it actually comes time to get your application approved. So I like to think of myself as a good middle ground. I'm not too expensive because I have low costs and I'm not a litigator. But on the other hand, I take the care to make sure that I'm filing your application right the first time. So you'll find that my costs are pretty much in the middle of the road. All right, and then the final question is, what can you expect, or what will be required of you in the long term, meaning after your patent or trademark has been approved? So if you have a utility patent, you're going to have to pay what's called maintenance fees over the course of the next decade, and that will cost you several $1,000s. A design patent does not have application fees. The trademark has to go through a renewal process after 5 years, and then again after every 10 years, and those can be pretty costly too. In the long term, I also didn't mention that here, but patents expire. Trademarks can live forever as long as you keep renewing them. But the utility patent lasts for about 2 decades, and the design patent for 15 years. If you keep renewing your trademark, you can have it for your lifetime. That's all I really wanted to say in this video. I hope you found it helpful. My name is Scott Fagerland, and my website is fagerlandlaw.com. If you'd like to consider working with me to file a patent or trademark application, or maybe some other small business concerns, please see my website, where you'll find an appointment calendar, and you can schedule a free 30-minute consultation in person, on the phone, on Zoom or Skype. So hopefully I'll be having a chance to talk to you soon about your patent or trademark.